Welcome to the A Better Life Together Inc. Bridge Project Family Warriors Family Group. A lot of you all probably saw we were calling this the Parent Warriors Parent Group, but as I shared just a few moments ago, we want to be mindful of the village in total that is responsible for caring for our loved ones who are individuals with disabilities. So, welcome to our first Family Warriors family group. If you missed last month, that's okay because we're going to go over everything that we went over. Just really briefly, what we believe is that people with intellectual and developmental disabilities have the right to services and supports to help them live their most independent and productive lives possible. And the Bridge Project, which we've mentioned a few times tonight, is a grant awarded by the Department of Developmental Services to A Better Life Together to determine the challenges some consumers of the San Diego Regional Center face in accessing services and supports they need. The goals of the project are to educate members of the community about services available so those individuals can get the supports they need to live their most independent life. We're explaining the California Regional Center system and how that system works to our families. And we're assisting individuals and families navigate the San Diego Regional Center system to get the most robust plan for supports possible. And we also explain the Lanterman Developmental Disabilities Act and how that law protects our rights to services and supports through the Regional Center. BRIDGE is an acronym, and that stands for Bridging Resources into Diverse Groups Everywhere. Now, our Family Warriors family group goal is to empower family advocates. And I wanted to just briefly share what is the Lanterman Act. This is the law that gives people with intellectual and developmental disabilities the right to services so they can live an independent and productive life. And this act is part of the California Welfare and Institutions Code. The Regional Center is your starting point. And so a little bit about me. I'm originally from Kansas City, Missouri. I have been with A Better Life Together and on the Bridge Project since August 2020 when I started. I have two sons that are 15 and 16. My 16-year-old, that's Kendall there in the front, he is my son on the spectrum. He has executive function challenges, and ABLT Inc. and the Bridge Project is truly rewarding because I get to connect as you all are connecting with us. I am also connecting with you. I'm learning from you as you all are learning from me. And we're all fellow special needs families. I get to do this daily. I've counted as a blessing to be able to share the things that I've learned throughout this 16 years. Some questions I get answered from you all. Some questions that I had when I started, I'm able to share those answers that I found. And again, that's truly the most rewarding part of working here with A Better Life Together in the Bridge Project. So, about our guest tonight, Attorney James Diskint is the founder of the IHSS Law Office, and ever since his younger brother Jeremy was born with Down syndrome, he has been an advocate for individuals with disabilities. I think that he is the perfect person to share with us tonight about IHSS protective supervision. Just to tell you a little bit more, Jeremy now lives in an inclusive home with the support he needs to thrive. And it took years of dedication, empathy, and problem solving for James and his family to help Jeremy get there. And these are the same qualities that Attorney Diskint will speak of tonight. And should you need him, that he can bring to your case. So at this time, I want to stop share. And Attorney Diskint can take over from here. Welcome, Attorney Diskint. We're still in a pandemic and we're still virtual, so don't let this hand touch this hand. Do the COVID clap. Welcome, Attorney Diskint, and welcome everyone this evening.
Well, thank you so much, Melissa. I appreciate that introduction. Also really appreciate the invitation to speak tonight. I really admire the work that you do with the Bridge Project. when you gave that intro there, it really made me think that our interests are perfectly aligned. I share a lot of the identical values that you guys do, and so it's really my pleasure to be here tonight. Hopefully, it can be helpful. So I wanted to speak about one particular service called protective supervision. I'm gonna, let's see, share my screen here. Okay, so everything that I'm gonna be speaking about tonight is on my website, IHSSlaw.com. So if you want to take notes tonight, great, but if not, all the information is readily available online. And so first, I wanted to give a brief introduction about in-home supportive services in general. That's what IHSS stands for. Before I do that, let me just give a brief disclaimer that nothing that I'm going to be presenting tonight during the webinar is intended to be legal advice. I'm trying to just provide some hopefully helpful general information. If you do need legal advice, then you should contact an attorney because the facts of your case might differ from someone else's. So I'm going to try not to speak about particular facts of anyone's case and just share some more general advice tonight. I'm going to try to minimize this. Hold on one second. Okay, hopefully that's better. Melissa, can you see the screen well?
I can.
Okay, great. So as I was saying, I want to give a brief introduction about in-home supportive services in general. And then I would love to talk about protective supervision in particular for the rest of the time. So in-home supportive services, also known as IHSS, is a California benefits program. It's designed to help people of all ages live safely at home. So IHSS pays recipients to hire a caretaker, and that personal caretaker can include a family member, including a parent, to assist with activities of daily living. So to be eligible for in-home supportive services, you must be a California resident, qualify for Medi-Cal, and either be at least 65 years of age, disabled, or blind. So IHSS is intended to be an alternative to out-of-home care. It's administered by the county welfare departments under the authority of the California Department of Social Services. That's the agency in charge, but typically you're going to be dealing with your local county welfare department. And so the state through the county through the state can pay providers up to 283 hours per month for in-home supportive services. And so that means that a parent, relative, or other caretaker can potentially earn more than $4,000 a month assisting their loved ones at home. So I'll show you quickly, for each county, there's different wages that are assigned. So for San Diego County, for example, the hourly wage that you would get is $15.50. And so, this is a potentially significant resource designed for families so that your loved one can live at home safely. Here are all the various in-home supportive services, ranging from assistance you can get with meal preparation, meal cleanup, shopping for food, routine laundry. If you need assistance going to the bathroom, assistance with feeding, assistance with dressing. There's really a range of services here, including paramedical services. So really there's a wide range of services, as you can see, that are available. And I really encourage all parents and guardians to look into more about each in-home supportive service in particular, so you can see what's offered and see what services your loved one might need. Tonight, though, I'm going to be focusing on one service called protective supervision. And this service provides potentially the most amount of hours that a caretaker can receive. It can provide up to 283 hours per month. As I said, that can turn out to be more than $4,000 per month. So what is protective supervision? Protective supervision is designed to provide oversight so that your loved one can avoid injury or accident. It's designed for folks who lack safety awareness, and so they might engage in potentially dangerous behaviors around the home. So next, I'm going to talk about the eligibility requirements for protective supervision. This is very important, and I'm going to be spending a decent amount of time on this because oftentimes parents call me and they said that they just had an assessment with the county social worker, and they didn't even know about protective supervision, perhaps, or if they did, they didn't know what to say and how to qualify for protective supervision. So there are four main requirements for protective supervision. One is that the applicant be non-self-directing due to a mental impairment or mental illness. Two, be likely to engage in potentially dangerous activities. And three, need 24-hour-a-day supervision to remain safely at home. So I said four requirements because for minors, if you have a child 18 and under, then there's a fourth requirement, which is that your child would need to establish that he requires more supervision than a child of comparable age who is not mentally impaired. Again, this is a service for residents of California of any age. I help families out who their loved one is, for example, an elderly person who, say, has dementia. I also help many families out where their loved ones are children who are just 3 or 4 or 5 years old. It's important to note that there is no minimum age requirement for protective supervision. So really, this program is designed for any applicant who can meet these requirements. So again, these are the four main requirements: that you have to be non-self-directing due to a mental impairment, likely to engage in potentially dangerous activities, need 24-hour day supervision to remain safe at home, and 4, need more supervision than a child of comparable age who is not mentally impaired. So I want to go through each one now in a little more detail so you have a better understanding of these requirements for protective supervision. So what does non-self-directing mean? The first requirement. So the Department of Social Services defines non-self-directing as an inability due to a mental impairment or mental illness for individuals to assess danger and the risk of harm, and therefore the individual would most likely engage in potentially dangerous activities that may cause self-harm. So here are some examples of potentially non-self-directing behavior: touching the hot stove, wandering away from home, headbanging, engaging in other self-injurious behaviors such as scratching oneself, also mishandling sharp objects, climbing to high places and jumping off, misusing the microwave, perhaps by putting metal objects in the microwave, eating inedible objects, playing with electrical outlets. So these are just some examples. Really anything like this where the applicant is engaging in some kind of potentially dangerous activity. I want to note that this is really can be a source of confusion, not only for families, but also for the county social workers. And unfortunately, I've seen many times with the administrative law judges themselves, in the event that you get a denial and then you have to appeal that. There is an appeal process if you get denied protective supervision or any other in-home supportive service. And unfortunately, this non-self-directing requirement is the source of a lot of confusion. So part of the reason I think there's a lot of confusion around it is because self-directing, as many parents here may know, has a different meaning in, say, the IEP context, where the term self-directing refers to a child's ability to make decisions without or with external control. So again, non-self-directing refers to a person's inability to make decisions without external control. That's typically what the understanding of self-directing is. But again, that's not the meaning here that under the Department of Social Services for protective supervision purposes. Non-self-directing essentially means that the child or applicant lacks the ability to understand danger and the risk of harm. So one of the ways to determine whether a child or applicant is non-self-directing is to evaluate the applicant's mental functioning. And so this is another component of protective supervision, is that the county social worker will assess your child's memory, orientation, and judgment. These are the three areas that will help the county social worker make a determination whether your child lacks the ability to understand danger and the risk of harm. It should be noted, and I'll talk more about this a little later, I think, when I actually go through some of the documentation that is needed for protective supervision, that typically applicants who are rated to have severe deficits in memory, orientation, and judgment are more likely to qualify for protective supervision than applicants who either have moderate or mild deficits in these areas. So that's really non-self-directing in a nutshell. Again, the key point here is that you have to establish that your child lacks safety awareness and that they don't understand danger and the consequences of their actions. So let's turn now to the second eligibility requirement for protective supervision, which is the applicant has to be likely to engage in potentially dangerous activities. So of course, an applicant is never required to suffer an actual injury in order to be eligible. That would be quite a cruel policy from the state. And hopefully you have measures in place to try to prevent your loved one from engaging in potentially dangerous activities. So actual injury is definitely not a requirement. Instead, the applicant must show a propensity for placing him or herself in danger. So for example, an applicant with a documented history of non-self-directing behavior who has a tendency to open the front door and start walking away does not necessarily have to make it into the street in order for this to be considered a potentially dangerous behavior. Let's see, the definition of non-self-directing already includes the requirement that the individual will most likely engage in potential dangerous activities. So I'm noting here that the state's requirements are a little redundant, and that's another source of confusion potentially. But this requirement is essentially, you want to think of a range of dangerous behaviors. You can create a dangerous behavior log, and I'll talk about that a little later in the next section regarding documentation. But it's important to become familiar with the different behaviors that your child engages in on a daily basis, if that's the case. Of course, you're going to be, familiar with it, but it's very important to keep a list and identify precisely the various dangerous behaviors that your child or loved one engages in. It's important evidence, and it's important to share that information with the county social worker at the initial assessment. Also, just important to note that recipients of protective supervision must be physically capable of harming themselves. So if your loved one is bedridden and they're not actually physically capable of doing something that's dangerous, then that would not qualify for being likely to engage in potentially dangerous activities. So for example, a fully paralyzed person is not capable of putting him or herself at risk of harm, at least under the state's understanding of this eligibility requirement. Although just because someone is confined to the bed doesn't mean that they're not physically capable of hurting themselves. I have several cases like that right now, actually, where applicants are bedridden, but they still are scratching themselves and doing other potentially dangerous self-injurious behaviors. So that could still qualify for protective supervision. Turning now to the third eligibility requirement, which is establishing that there's a need for 24-hour-a-day supervision. So of course, no applicant engages in potentially dangerous activities every minute of every day. But the 24-hour-a-day requirement means that the dangerous behaviors are frequent and unpredictable so that the constant supervision is necessary. Those are really the key two factors here, is that the behaviors need to be frequent enough and unpredictable so that these dangerous behaviors could happen any time of day. When parents ask me, well, how frequent is frequent for purposes of this 24-hour-a-day supervision, I say there's no bright line rule, but I typically say around once a day or at least once a day. Many of my clients that I'm helping right now engage in potentially dangerous behaviors multiple times a day. And so that would, in my opinion, fulfill the 24-hour-a-day requirement, especially if those behaviors are unpredictable. So, for example, if a child touches a hot stove, that would qualify for this behavior we just talked, for this requirement we just discussed of likely to engage in potentially dangerous activities. Touching a hot stove certainly shows that you lack safety awareness, which is the first requirement. So touching the hot stove would also then satisfy the second requirement. But regarding the 24-hour-a-day requirement, if, for example, your child only touches the hot stove, say in the morning when you're making breakfast, say you're making scrambled eggs or something and you have the stove on, that potentially could be considered a predictable behavior because it's happening at certain times of the day. And so again, the behaviors need to be unpredictable. They need to happen at any time of day or night so that 24-hour-a-day supervision is warranted. I also want to mention that it is the state's policy that you can leave your child or loved one alone for some short fixed period of time. That itself is not a reason to deny protective supervision. So again, you don't need to be providing supervision literally every second of the day, but just supervision enough so that it's constant essentially, and that you're there to safeguard against any kind of unpredictable behavior. So now turning to the requirement about, there's an additional requirement, as I mentioned, for children. And I think that's especially relevant for tonight since there's a lot of parents here. There is an additional requirement that you need to establish that your child requires more supervision than a neurotypical child of the same age. So how do you establish more supervision? Well, more supervision could mean more time supervising your child or more intensity of supervision than a neurotypical child of the same age. So one way to determine whether your child needs more intensity of supervision is to look at the nature, frequency, and duration of the interventions necessary to prevent injuries and compare those to the interventions necessary for a neurotypical child. So for example, you should be thinking about how frequently your child attempts these dangerous behaviors compared to a neurotypical child. For example, let's say that your child jumps off from high places and has no awareness of height and the danger associated with jumping from high places. Well, perhaps a child of the same age, if say your child is 2 or 3, a neurotypical 2 or 3-year-old might also do the same, arguably. And so you want to try to establish that your child is engaging in this behavior more frequently than a neurotypical child. You also want to consider whether the dangerous behaviors are similar to those of a neurotypical child. So some of the examples I gave before of potentially dangerous behaviors and non-self-directing behavior could include self-injurious behaviors such as scratching yourself or head banging. Those are certainly some of the more extreme behaviors that I've come across. Really, those types of self-injurious behaviors, in my opinion, are not seen typically by neurotypical children. So if you can establish that the type of behavior your child is engaging in is more extreme than a neurotypical child, then that's another way to potentially establish that your child needs more supervision. Let's see. Also, the duration of interventions. If your child is trying to wander away from home, for example, and you constantly need to redirect your child, and maybe you need to calm your child down if he's going to be exhibiting tantrum-like behavior, that could take a long time to calm your child down. All these types of things really you should take notes about, you should record, because these are ways of establishing that your child might need more supervision than a neurotypical child. I will note that, as I said above before, there is no minimum age requirement for protective supervision. So I have helped minors as young as 2 and 3 years old qualify for protective supervision. But I will say that the younger the child, the harder it is, of course, to establish that your child needs more supervision, because obviously the younger the child, the more supervision he or she requires. So that's why these factors can be, very important in trying to distinguish your child's supervision needs than a neurotypical child's. Also, something to consider here is, depending on the age of your child, the first eligibility requirement we spoke about, which is whether your child is non-self-directing, which again means that your child lacks safety awareness, if they are non-self-directing. So going back to these what we call the mental functioning, there's 3 areas of mental functioning: of memory, orientation, and judgment. These areas, again, your child is going to be evaluated on a 3-point scale. The social worker is going to determine whether your child has severe deficits in these areas. So say hypothetically that your child does have severe deficits in memory, orientation, and judgment. Well, that is relevant information then to consider for this 4th requirement, whether your child needs more supervision. So for example, let's go back to a common behavior. Let's say that climbing to high places and jumping off, say hypothetically, is considered common behavior for a 2-year-old. I'm not sure if that's the case or not, but say hypothetically it is. So even if it is a common behavior, your loved one might still require more supervision, even if he or she is engaging in common behavior, because your loved one, we're saying, has hypothetically has severe deficits in memory, orientation, and judgment. So that means they don't understand the consequences of their actions as well as a neurotypical peer. It also means that they are not remembering the warnings that you constantly give to your child. So while it might be common, let's say for a neurotypical 2 or 3-year-old to engage in some potentially dangerous behaviors and maybe try that out once, let's say hypothetically, or a couple times, most neurotypical children learn from their behaviors, learn from their accidents and mistakes, and listen to the advice of their caretakers, including parents. So that's potentially one area that you can use to differentiate your child from a neurotypical one regarding this 4th requirement of more supervision. I want to talk about some exceptions to protective supervision eligibility. So protective supervision is not authorized in these following situations: for friendly visiting or other social activities, for routine childcare. Again, that's connected to this above requirement of needing more supervision than a neurotypical child. So again, it cannot just be routine childcare. Also, protective supervision is not authorized when the need is caused by a medical condition and the form of and the form of supervision required is medical. Also, it's not authorized in anticipation of a medical emergency. It's not authorized to prevent aggressive or antisocial behaviors. So that includes, hitting someone else, any type of aggressive behavior towards someone else, as opposed to self-injurious behaviors. Self-injurious behaviors are, those are the types of behaviors you're looking for protective supervision, whereas aggressive behaviors towards others are not authorized. Also, there's an important exception here when the applicant deliberately intends to harm him or herself. So again, that kind of connects back to the first eligibility requirement we discussed of being non-self-directing, which is that you lack safety awareness. Well, if you don't lack safety awareness and you're found to be self-directing, then protective supervision is not authorized, because then potentially the applicant is deliberately intending to harm him or herself. And while that certainly is cause for concern, it's not covered under the protective supervision program. So I'm just keeping an eye on the clock here, because I do want to leave at least 20 minutes at the end for questions. Melissa, feel free to cut me off if I'm kind of in the middle of something, but I'll try to keep an eye on the clock, because I do want to leave time for questions.
Okay.
I wanted to talk next about what documentation you need for protective supervision in order to qualify. So that this really depends on the age of the applicant, the age of the loved one you're trying to get protective supervision for. Again, as I mentioned, I help folks of all ages qualify, ranging from young children to elderly folks. So depending on the age, there's going to be different relevant documentation. All applicants, though, regardless of your age, need to fill out an assessment of need for protective supervision. This form is called SOC 821, and I'll just show it to you real quickly. This is where your child's pediatrician or the applicant's doctor fills out whether the applicant has severe deficits in memory, orientation, and judgment. Again, as I mentioned before, in my experience, typically applicants with severe deficits in these three categories are more likely to qualify for protective supervision. That's not a guarantee by any means. I've also seen cases where the applicant's memory and orientation perhaps can be moderate, have some kind of moderate deficit, but their judgment be severely impaired. There's not one way to go about it, but just typically the more severe the deficits, the more likely it is to get protective supervision. So this is one form that is going to be needed for your initial application for protective supervision. Another form that many parents here may already be well familiar with is the Individualized Education Program, known as an IEP. This is the document that is relevant for your child's placement in school. This can really be a very important document in establishing your child's needs, whether your child needs a one-to-one. And if there is some time, I can talk about the IEP at greater length. If there's not time, I just want to show everyone here. This is my blog under the news tab. So if there's not enough time during this evening's webinar, you can scroll down to my blog, and check out this post, how an IEP can help or hurt your case for IHSS protective supervision. I do get a lot of questions about IEPs. I'm not a special education attorney, so I can't advise you about what's best needed for your child's placement in school. but I can tell you solely from a protective supervision standpoint, the types of things that can be helpful to establish your child's need for protective supervision. So I'm just pointing you to that, and if there's more time, I can go over that. Other documentation you might want to look into is if you're a client of the regional center, perhaps an individual program plan or other regional center document can be helpful. Again, what you're trying to do here with the documentation is you're trying to establish your child's need for protective supervision. And how do you do that? By going through the eligibility requirements that we discussed. So the documentation you produce should discuss whether your child lacks safety awareness, whether they engage in potentially dangerous behaviors. If they do, it's very helpful for the document to really specify what behaviors your child engages in, how frequently your child engages in these behaviors, and whether the behaviors are predictable or not. Other potentially helpful documentation can include any evaluation or report from some type of assessor who's going to be looking at, who's going to be observing your child and taking notes. So this can include, for example, like a psychoeducational evaluation. Any kind of assessment or report is really going to be helpful. Also, if your child is supervised by anyone other than yourself, having letters from potential witnesses. This can include neighbors. Perhaps your child is in ABA therapy. So then your child's therapist could write a letter in support. It's really helpful to produce and try to get this documentation, because you don't want it to just be your word as the parent against the county social worker's word. You really want to have more supportive documentation than just that. Part of the reason for that is because, unfortunately, like any benefits program, there can be cases of fraud. As I mentioned in the beginning, this is a very valuable service for families. It can get you potentially more than $4,000 a month to care for your loved one. And like any benefits program, there can be abuse and fraud involved. So one of the ways of the county social workers and the state to weed out any cases of potential fraud is to just make sure that you have supporting documentation, that it's not just your word, but that there's other objective folks who have personally observed your child who can also vouch for you. So let's see, that's just an overview of some of the documentation you need. Let me quickly talk about, I'm going to skip how you apply, because it's pretty straightforward. You can go on my website. There's an application form that you fill out and submit to your local county IHSS office. That's pretty straightforward, but the information, again, is all here on my website. I want to just briefly go into what happens at the initial assessment. So after you apply for protective supervision, which again, you can follow this step here, your county social worker is going to contact you and schedule the initial assessment. So during COVID, this initial assessment was happening over the phone mostly. Now there's more in-home visits for these initial assessments. Essentially, it's an opportunity now for you to meet your county social worker, for you to establish and essentially prove why your child needs protective supervision, and not just protective supervision, but really any other in-home supportive service. In the beginning, I went over some of the other various in-home supportive services. So but potentially, your child could qualify for protective supervision as well as other in-home supportive services, or maybe not protective supervision, and only other in-home supportive services, which again are designed to help your child live at home safely and help with tasks of daily living. So the county social worker is going to schedule a home visit, and again, well, not only is there an initial assessment, but then every year the county is supposed to conduct an annual reassessment. So during this home visit, the county social worker is going to make his or her own observations and take notes on your child's need for protective supervision. And the social worker assesses the applicant's physical and mental functioning, living situation, and ability to perform activities of daily living. The social worker will also ask questions regarding the applicant's safety and well-being, essentially seeing whether your child engages in potentially dangerous behaviors, and the county social worker should go through the above eligibility requirements and help you determine whether your child needs protective supervision. There is an appeal process in the event you get a denial of protective supervision. Hopefully you don't. If you do, then you have the right to request a hearing. That's typically the part of the case where I get involved. I help many families with their appeals, but that's, I think, beyond the scope of tonight's webinar. So with that, Melissa, I'm happy to turn it over for some questions. Just so I want to make sure that we have enough time.
Well, I first just want to thank you, Attorney Diskint, for being with us tonight. This has answered a lot of questions that I personally had. Your presentation itself, and then I just wanted to point out literally every phase of IHSS as well as protective supervision is pretty much well covered on IHSSlaw.com. I have been referring to it heavily here in the last few months since I became aware. We did have one question that was put into the chat. Early on in the presentation, you talked about needing Medi-Cal. So Kamika was wondering who needs to have the Medi-Cal, the provider of care or the recipient?
Yeah, that's a good question. The recipient needs to qualify for Medi-Cal.
Okay. Okay, and then it looks like we have one more. Jeannie, thank you for your question. Does the amount of the family income affect the amount of IHSS support?
So I think that's really related to the first question potentially of Medi-Cal eligibility. So, I think income plays a role in Medi-Cal eligibility, but Medi-Cal eligibility really is not my expertise at all. And so I can't really answer that directly. There is a helpful organization that I typically refer my clients to called medihelper.com. Just verify that's the.
And I think she was asking in regards to like if you make over a certain amount, will they disqualify you for IHSS from being a provider for?
Right. So that is a Medi-Cal eligibility type question. The only requirement for the only related requirement about that for in-home supportive services is that the recipient is Medi-Cal eligible. But in order to be Medi-Cal eligible, income, I believe, is considered, although I do not know all the different ways to qualify for Medi-Cal. So that's why, yeah, there's an organization called Medi-Cal Consulting Services. They give a free consultation. Their website is medihelper.com, MEDI helper.com. I can copy that.
I'm putting that into the chat.
Wait, yeah, MEDI helper.com. And I think they can answer all your Medi-Cal related questions. But yeah, I focused primarily on in-home supportive services and really protective supervision in particular. And so typically when folks contact me, they've already qualified for Medi-Cal. But yeah, that is an important first requirement.
Okay, and then we had Jeannie was just clarifying that previous question. She said that her son is over 18, and that was in regards to the family income affecting the amount of support. I think that likely that first step is going to be the Medi-Cal eligibility, because that is where there is a threshold or an income threshold that you can't exceed to be eligible for Medi-Cal. So I think that we could take actually, Jeannie, I will put up before we disconnect. I will put up my contact information again, or actually, I can just paste it in here to the chat, because I can help you with that part of things. But I thank you for your question, and I can kind of take a deeper dive with you offline for that portion. And then Samantha was wondering, does aggression make the applicant ineligible? And she says she didn't really understand that part. What I did want to, before Attorney Diskint answers that, he made a very good point about documentation. And this is kind of one of the things that I found was a recurring theme these last couple years working on the Bridge project. If you do not have your most recent copy of your IEP, if you have an older child who is with the regional center and you don't have a copy of the IPP or the IFSP that Attorney Diskint mentioned, it is going to be square one, step one, phase one, for you to just get a binder together. If you do not have a binder, at one point, what I'm about to show you, this is actually, because I'm working from home today, this is actually right next to me, you all. This is an accordion that I bought from Amazon for $15. It's $15.99. Kindle is $16. So we started out with something like this. And let me make sure I'm getting it. Just a folder. But over the last 16 years, we've had many evaluations. We've had allergy and asthma clinic visits. We have had IEPs for every year. We have had to have we've had to bring in an attorney when I was back in Missouri. We've had to do functional behavioral assessments. If you have ever had a situation where the IEP isn't being followed, you might need a functional behavioral assessment because they're not giving grace and understanding of, different things going on. My purpose in showing you this accordion, for $15, I've got my son's whole life in here. There's still a section for senior year next year. The importance of documentation is, if you don't have a log of it, it did not happen. If you cannot refer, and this is just like you capturing the day. Oh, Melissa, don't give us one more thing to do. I'm sitting here as a fellow parent, and I'm telling you how valuable it is going to be to have those documents and to keep a log of behaviors and to have a communication log of what you've discussed with the IEP team, with your regional center service coordinator. When you sit in on Zoom calls or family groups or parent groups like this and you take notes, it's going to be so valuable. I cannot say that to you enough. Most of my time when I first connect with a family is spent gathering those documents. But if you start now, then you can move forward from a sure-footed place. And when I say sure-footed, that means that you have a good starting point if you have your documentation. Any emails that you have received, you can digitize this as well. And we're going to have some other parent and family warriors, family group meetings, so that I can teach you things that I had to learn the hard way. I feel like they probably put the perfect person with you guys, because a lot of this, I'm just able to tell you, oh, you should do this. You can sign documents on your phone. You can scan documents on your phone if you have a smartphone. I'll be doing tutorials to share with you how to do that. I didn't want to get too far off base, but I didn't want to forget to show you all, like, documentation is important. I don't know when I'm going to throw anything away from there, because I feel like I need it all.
Well, Melissa, thank you so much for emphasizing that. I completely agree. It's really a great point. Documentation really is the name of the game for protective supervision and in-home supportive services. It's not going to be enough in most cases for you to just tell the county social worker, oh, my son or daughter needs protective supervision, and say what happens. You're going to need to prove to them, you're going to need to demonstrate that that's the case, and documentation is how you do it. Just, I wanted to add one point about documentation that's very important, is that you really try to pay attention that the documentation that you collect in a binder like the one that Melissa just showed, it's very important that the documentation is consistent, and that you should try to focus on the eligibility requirements that we discussed this evening. So again, if you think that your son or daughter or your loved one might qualify for protective supervision, then what you want to do is you want to prove those eligibility requirements. So for example, when you have an IEP, if your child engages in these potentially dangerous behaviors at school, well, then your IEP really should address those dangerous behaviors specifically. The IEP could also have a safety awareness goal, for example, for your child, because again, we said that one of the eligibility requirements is that your loved one has to lack safety awareness. So you have to prove that, right? You need to prove that with your documentation. So turning away from the IEP and going, so let's talk about the IPP that Melissa just mentioned, and I talked about before from the regional center. When you have when your regional center representative is helping you with the IPP, you want to make sure that you tell the regional center representative that your loved one, your child, is engaging in these potentially dangerous behaviors at home. And you should make sure, as an advocate, as a parent advocate, you need to make sure that the IPP that's going to come out of that meeting is going to clearly document the different dangerous behaviors that your child engages in at home. Because and I've seen this many times, and it's always a shame, is that a parent will say, oh, my child needs protective supervision. They engage in these potentially dangerous behaviors, and they'll give me, a list of whatever it is, 3 to 5 dangerous behaviors. And I'll say, okay, let me see the documentation. And they'll email me the IPP, they'll email me an IEP, maybe they'll email me a letter from an ABA therapist. And nowhere in these documents does it talk about dangerous behaviors. Nowhere in these documents does it talk about the child lacking safety awareness. Well, that's a major problem then, because you're most likely going to get denied. And not only if none of the documents discuss these things, but say even, for example, one of the documents, like an IEP, does not mention these dangerous behaviors. So, for example, you have your initial assessment, and you give the county social worker your child's IEP. You give the county social worker your child's IPP. Say, for example, 2 of the 3 documents you produce talk about your child's dangerous behaviors, but then the IEP doesn't say anything about dangerous behaviors. The IEP says nothing about safety awareness. Well, even though you produce some documentation that discusses it, the documentation now is inconsistent. And unfortunately, in a lot of situations, the counties are really looking for any excuse to deny you protective supervision. Again, that's just my opinion based on my experience, because the reality is this is an expensive program that the state offers, And the state really wants to make sure that it's only for applicants who really are deserving of it. So if they look at your documentation and they say, okay, the IEP doesn't discuss any dangerous behaviors, it doesn't discuss that the student lacks safety awareness, well, then they can potentially make the conclusion that these behaviors aren't happening at school. Um, so I'm just giving that as an example. It could be the IPP, or really any other document that you produce. If it doesn't discuss the dangerous behaviors, or the doctor's form, for example, that I showed briefly, if the doctor's is going to check off that your child has no deficit or a mild deficit in judgment, that's most likely going to be used against you in your case. So I always encourage parents to kind of take ownership of the documentation aspect of this case, because I think that's really the one part that you have potentially the most control over. And before you go into that initial assessment with the county social worker, you really want to have all your documentation lined up. I think that binder militia showed is a great way of keeping track of everything. That's really your avenue and ticket to getting protective supervision. But I think I went off course a little bit. I want to answer this question, if I can, real quick, Melissa. Is that okay?
Yes. Does the aggression make the applicant ineligible?
Yeah, that's a good question. So, so I mentioned that aggressive behavior is defined as doing something towards someone else as opposed to injuring yourself. So if your child is hitting someone else or pulling someone else's hair, those types of behaviors don't constitute potentially dangerous behaviors for protective supervision. So the types of behaviors we discussed that do qualify are self-interest behaviors. If your child scratches themselves or bangs their head, or other dangerous behaviors can include touching the hot stove, wandering away from home, jumping from high places, playing with the electrical outlets. These are just examples of dangerous behaviors that are causing your child to be hurt, not someone else to be hurt. Now, the question says, does aggression make the applicant ineligible? So even if your child engages in some aggressive behaviors, but also engages in potentially dangerous behaviors that would qualify. So say, for example, your child wanders away from home, tries to escape. Maybe they scratch themselves and until maybe the point of bleeding, hopefully not, but I have seen that in certain cases. Say your child tries to touch the hot stove. These are all potentially dangerous behaviors, but if your child also engages in aggressive behaviors, hitting someone else, they would qualify because they also engage in potentially dangerous behavior. So just because your child engages in aggressive behaviors does not mean you're not eligible for protective supervision. It just means those aggressive behaviors are not going to count towards protective supervision, if that makes sense. The key is potentially dangerous behaviors and self-injurious behaviors.
Our next question was from Claudia. How are the hours decided when there's a parent and another provider when they are under 18? So is it you're referring to the person receiving the care is under 18 or the other provider is under 18? I think I know the answer to this, Claudia, but I just want to be sure. Claudia, you're still on mute.
Oh, I'm sorry, I typed it in. It's my younger son. He's under 18.
Oh, okay. So how are the hours decided when there's a parent and another provider when her son is under 18?
Yes, because I was told since he's under 18, he would get more hours if the parent is the only provider.
Okay.
Thanks for your question, Claudia. I can't go into all those specifics about the requirements for parent providers. That's kind of like a whole other topic. It's definitely important. If you want to send me an email. My email is on my website. I'm happy to send you some information about that. But I prefer not to address that now because it just opens up a whole other area of how parents qualify as providers, and how to divide up time.
No, I understand. Thank you.
Sure.
Yeah, I will email you. Thank you.
Okay, great. Thank you.
Okay. It looks like that was the last of our questions. I just want to share because I know we had a few that were some of the things that Bridge Project and myself and Avon and also Veronica with A Better Life Together we handle. I want to provide you all with my work cell number, 0271. You all are welcome to call or text. And then I also want to provide my email address. And then I'm going to also share Attorney Diskint's information. I did have it in the chat earlier, but I'm just going to do that again. You can actually send him messages and emails directly through the website, but his web address is IHSSlaw.com, and I've added that to the chat as well.
So let me just add to parents are always welcome to give me a call. They can email me. My email address is support@ihsslaw.com. Support@ihsslaw.com. You can also find that on my website. As Melissa said, you can just type in your question to my website directly, or you can shoot me an email, call. I try to make myself available to really answer any question you have.
Okay, I've shared your email in the chat as well. And it looks like that was all of the questions that we had for this evening. For all of you all who joined just a few minutes late and missed my introduction and my introducing Attorney Diskint and the very beginning, this will be up on our website, the recording, on our video replay page by Monday afternoon, if not sooner. Those of you all who join me for the Wednesday webinar, you know the webinars are normally up by Friday afternoon like clockwork with slides and links. I need you all to give me just a few more days because one day later in the week makes it just a little more difficult. But I do want you all to feel free to reach out to me. If you receive this email and you are one of our Bridge families, and that's what brought you here, but you've never talked to me before, I definitely see familiar names, but we may not have spoken. Call me, text me, feel free to email me. I am available either of those ways. We want to help you get the services and supports that you need. If for any reason you haven't had an opportunity to get Attorney Diskint's information down and you're just like, hey, I need his email again, Melissa, call me, text me, email me. We will connect you all, give you that information. But if we could, and I see everybody is back behind the black screens again. I told you all it's easier to talk to smiling faces or even those who have that look that I had yesterday when going over homework with Kendall. The bewildered look. I understand. I'm here with you. Believe you me, I want to thank you all for joining us this evening. Attorney Diskint, if we could just do our COVID clap, that means don't let this hand touch this hand. Okay, we just wait.
Thank you.
Gotta stay COVID free still. Thank you all so much for joining us. If you have any questions, if you need anything, you can call me. This is truly what I enjoy. I want to help you all get the things that you're needing for your family members, for your children. Thank you so much. Y'all look beautiful. Y'all look amazing tonight. Thank y'all so
Thank
much.
you, everyone. Thank you, Melissa.
Have a blessed evening, everyone.